what is that judicial review? Hi everyone, welcome back to the episode 15 of Iuris Scientia for the Soul. I'm Kara Hugh, the Exco Muting of 80th UUM Law Student Society. Today, the legal principle that I'm going to share with you is the factors that the court would take into consideration in applying judicial review on the decisions of the administrative bodies. The prerogative power of the court to apply judicial review is rooted under Section 25, subsection 2 and paragraph 1 of the Schedule to the Courts of Judicature Act 1964. So under Section 25, subsection 2 of the Courts of Judicature Act, it provides that the additional power laid out in the Schedule to the Courts of Judicature Act shall be exercised by the High Court in pursuance with rules of court or any related written law. Besides, paragraph 1 of the Schedule to the Courts of Judicature Act provided that the High Court has the power to issue any person or authority, statutory, prohibition, mandamus, habeas corpus, or any other remedies if it is found that there is a violation of fundamental liberties under the Federal Constitution. So, the first factor that the court will take into consideration in applying judicial review on the decision of the administrative bodies is whether the applicant fulfill the test for locus standi. The test for locus standi is embedded in Order 53, Rule 2, Paragraph 4 of the Rules of Court, whereby it provides that everyone has the right to apply judicial review if he is adversely affected by the act of the public authority. So from this, it shows that the test for locus standi consists of two elements, which are first, element of adversely affected, and second, element of public law. So regarding the element of adversely affected, the applicant will need to show sufficient evidence that his personal interest was adversely affected by the Public Authorities Act. Meanwhile, for the element of public law, the applicant must understand that only a complaint against a public authority is subject to judicial review. In case it is a combination of private and public laws, the court will have to determine which of them is more prevailing. If it is more to private law, the complaint shall not be subject to judicial review. Furthermore, another factor that the court would consider in applying judicial review on the decisions of the administrative bodies is whether the administrative bodies act within their virus. So this factor is based on the Doctrine of Ultravirus. Ultravirus is actually a Latin phrase with the definitions of without power or beyond power. So it means that the virus here is actually referred to power. In this regard, the court will review the case by examining whether the administrative body acts within their virus. So in determining whether the administrative bodies act within their virus, the court will examine whether the act of the administrative bodies has a legal basis. So if an administrative body acts in bona fide and has a reasonable objectives of acting it, such act shall be rendered valid and no judicial review will be made by the court. Thank you for watching and stay tuned for the next episode. See you!